5 seconds to go. Start. The land so reserved shall be free from any construction by the owner or promoter or developer. Stop. The land for communal and recreational purposes shall be restricted at a ground level in a shape and location to be specified by the Chennai Metropolitan Development Authority. Stop. Para. In the case of writ petition number 691 of 2015, wherein the regulation of the year 2008 has been challenged, as we have noticed, there is no challenge to regulation 29(6)(a), which inter alia provides how the land reserved is to be restricted at the ground level. Stop. It is true that there is a challenge to annexure 20, which we have extracted in paragraph 118 of the judgment. Stop. But the absence of challenge to regulation 29(6) is fatal. Stop. We must proceed on the basis that there is no challenge to the terms of the explanation to rule 19b, which in clause 3rd provides that the land so reserved shall be free from any construction by the owner, promoter or developer, and what is more important, the manner in which the land is to be provided for communal and recreational purpose is that it is to be restricted at ground level in a shape and location to be specified by the Chennai Metropolitan Development Authority. Stop. This provision has not been expressly challenged. Stop. In the absence of a challenge, what is contained in a rule and also the like provision in the regulation, the resultant position would be the exact shape and the location is to be determined by the CMDA. Stop. Para. The problem, however, still persists in the form of the meaning of the words communal and recreational purpose in the case of a site having an extent between 3000 square meters to 10,000 square meters. Stop. Rule 19 contemplate that the space so required is to be transferred to the authority or local body designated by the authority free of cost through a deed. Stop. It is further provided that the local body may provide the residents association or flat owners association for maintaining such reserved space as park. Stop. Significantly, in the case of a site having an extent between 3000 to 10,000 square meters, the rule declares that public access to the area as earmarked will not be insisted upon. Stop. When it comes to the extent of the site with which this court is concerned, viz, where the extent of site exceeds 10,000 square meters, the requirement in the rule, viz, is common to 10% of area, excluding road, had to be transferred by a gift is insisted upon. Stop. It is provided that it is obligatory to transfer the reserved 10% of the site area. Stop. No charges can be accepted in the case of new development or redevelopments. Stop. It will be noticed that in the case of Rule 19b, in the case of site having extent between 3000 square meters to 10,000 square meters, the CMDA or the local body may permit the residents association or flat owners association for maintaining the reserved space as parks. Stop.